the Honorable Chief Justice and members of the judiciary, my cabinet colleagues, distinguished guests, ladies and gentlemen. I'm very happy to join all of you at this SGLaw200 Youth Forum and to see many young Singaporeans gathered here. This year marks the 200th anniversary of Singapore's legal system. We are planning a series of events to mark this milestone, and this SGLaw200 Youth Forum is the first of the major events for this 200th anniversary. And I'm very happy that MinLaw and IPS have set aside this space for young people to reflect on what the rule of law means for our society and also for our future. When I speak with young people, the conversations usually turn to issues like mental health, inequality, and climate change. Rarely do they begin with the rule of law. But think about the things we sometimes take for granted. For example, how we can walk home at night safely without a second thought. How we might sign contracts confidently knowing that they would be honored. Or trust that we would be treated fairly, whoever we are or whatever our background. You probably didn't think about the rule of law in that moment, but it was there, and it is always there. And the moment it isn't, everything else begins to unravel. So what does the rule of law actually mean? If you ask different people, you might get different answers. Some will say it's about clear laws that apply to everyone. Others will point to due process, presumption of innocence, and the right to a fair hearing. Still others will say it's about balance, protecting individual freedoms while safeguarding the wider community. And all of these are valid, but beneath them lies a deeper point. As a French philosopher once put it, justice without force is powerless, force without justice is tyranny. And this is not abstract philosophy, it plays out in real life. Law enforcement has to work within a framework of laws, otherwise you risk abuse. But constrain that power within a framework too tightly, and criminals will exploit the gaps, and the guilty walk free, and the ordinary people pay the price. So the real challenge is navigating the space in between, where principle meets practice and difficult trade-offs have to be made. And there is no universal formula for success. Every country has to find its own balance, shaped by its history, its composition, its vulnerabilities, and its values. A formula that works in one country may be unsuitable to another. The rule of law is also not just about order or efficiency. It is about legitimacy as well. People must believe that the system is fair, that it treats them with dignity, and that justice is not only done, but seen to be done. Without that belief, even the strongest laws will not hold. So what is Singapore's approach to the rule of law? We are a small, multiracial and multi-religious society with people of different backgrounds and beliefs living in close proximity. Our history has taught us, sometimes painfully, how fragile harmony can be. And that is why for us, stability is not a preference. It is an existential necessity. Without stability, there can be no security, no progress, and ultimately no Singapore. This reality shapes how we approach the rule of law. We put a strong emphasis on safeguarding the wider public interest. We ensure that the government has the ability to act decisively and swiftly when circumstances demand it. But these powers are not unchecked. They are exercised within a system of strong institutions, an independent judiciary, a professional and impartial civil service, and regular and free and fair elections. As I said earlier, the key is balance. A system strong enough to govern effectively and constrained enough to prevent abuse. This balance works only because of trust. Singaporeans trust that the government they elect will exercise its powers responsibly. And the government, in turn, is accountable to the people for how these powers are used. And that trust did not emerge overnight. It has been built up carefully over generations, and it must continue to be earned and renewed. In the end, the test of any system is whether it delivers good outcomes for its people. The rule of law cannot just be an abstract principle. It must be something people experience in their daily lives, in the safety they enjoy, the fairness they expect, and the confidence they have in institutions. And let me illustrate this with 3 examples. First, corruption. In some countries, corruption is tolerated as part of the cost of doing business. But in Singapore, we've taken a strict zero-tolerance approach. Our laws are enforced firmly, investigations are carried out independently, and the standards apply to everyone, regardless of position or status. This is not just about maintaining a good business environment, because more fundamentally, it reflects a basic principle of fairness, that opportunities in Singapore are based on merit, not on connections or privilege. Second, drug trafficking. Imagine the police finds drugs or heroin in someone's luggage at Changi Airport. In many other legal systems, the prosecution must prove beyond reasonable doubt that the accused knew he was carrying drugs. But proving what someone knew is often extremely difficult. A person can always claim, I didn't pack my own bag, or I had no idea this was heroin, I thought it was something else. So that makes enforcement extremely difficult, and drug traffickers know how to exploit this. So Singapore takes a different approach. If drugs are found in your possession, the law in Singapore presumes you knew they were there. The burden shifts to you to prove otherwise. And this reflects a practical reality. You are best placed to account for what is in your possession. At the same time, there are important safeguards. Every case goes through a full investigation and trial before an independent judge. The accused has the right to legal representation, and in capital cases, the state appoints a lawyer for the defense at no cost. Every death penalty verdict is automatically reviewed by the Court of Appeal, even if the accused does not appeal. So the system is firm, but it is also fair, and it protects society while upholding due process. Third, speech and the online space. In some countries, even offensive speech is protected in the name of free expression. You can insult someone's race or religion, you can publish falsehoods online, and the belief is that bad speech can be countered with more speech, not legal restriction. With freedom of expression, with all sorts of things, true or false, good and bad, somehow enlightenment will emerge. Singapore takes a somewhat different view because words do not exist in a vacuum. Speech that demeans race or religion can divide society. It can polarize, it can normalize hatred. And history shows that it can lead to violence. And in a diverse society like ours, we cannot treat such risk lightly. So we have laws against speech that incites racial or religious hatred, and laws to counter the spread of online falsehoods. Some have criticized this approach as overly restrictive, but today, even societies that once took a more permissive approach are tightening their laws because they are confronting the same challenges and realities. And what once seemed overly cautious is increasingly seen as necessary. I've given 3 illustrations, and they are just examples that show the rule of law in practice and how it shapes the kind of society we live in. What has this approach delivered for Singapore? On the whole, I would say it has delivered good outcomes. Singapore today is one of the safest and least corrupt countries in the world. Public trust in our institutions remain high. People have confidence that the rules are applied fairly, contracts are upheld, and disputes are resolved impartially. None of this depends on any single law and institution alone. It depends on the entire system working together. Laws, institutions, norms, and values to keep society stable, fair, and cohesive. And that is what gives the rule of law in Singapore its strength. And none of this happened by chance. It is the result of deliberate choices made with a clear understanding of our context, circumstances, and constraints. But no system is complete or perfect. It is always a work in progress. And the balance we have struck today in Singapore is not fixed. What works today may not be appropriate for tomorrow. The world keeps moving, and our laws and institutions must continue to evolve and keep pace. For example, one major frontier is technology. AI is advancing faster than legal systems around the world can adapt and keep up. We are already seeing the consequences today: more sophisticated scams, deep fakes that destroy reputations overnight, misinformation that spreads faster than truth. These are not hypothetical risks, they are already here. And even harder questions lie ahead. When an AI system causes harm, a wrong medical diagnosis, a fatal incident involving a self-driving car, who should be held accountable? The developer who built it, the one who wrote the algorithms, the company that deployed the machine, or the person who used it? Our legal frameworks were not designed for a world where machines can make consequential decisions, so we will have to rethink some of our most fundamental assumptions about responsibility, liability, and accountability. Again, this will not be easy. Move too slowly, and the law falls behind, while people potentially get hurt. Move too quickly, and we risk stifling innovation. Once again, we must strike the right balance between safety and progress, between control and creativity. And even as we harness technology, we must be clear that the law ultimately rests on human judgment. Machines can assist, analyze, and recommend, but questions of responsibility, fairness, and justice cannot be delegated entirely to algorithms. These are human questions which humans must decide, and that must always remain so. Another challenge is access to justice. We can build the best legal systems in the world, but if it is out of reach for ordinary citizens, then it means very little in practice. A system only works if everyday Singaporeans can use it to find justice and enforce their rights. And here, Singapore has taken important steps forward. The Public Defender's Office, established in 2022, was a significant milestone, ensuring better access to justice for accused persons who cannot afford legal representation. But access to justice is not just about lawyers or courts. It is also about legal awareness. People must know their rights and understand how to exercise them. Otherwise, the protection of law only exists on paper. It is also about ensuring that the legal system caters to the needs of everyone. And here we know that gaps still remain, especially for vulnerable groups who may not know how to navigate the legal system. This is why the Ministry of Law has set up a task force to promote a more inclusive justice system, drawing on public agencies, legal professionals, and community partners to identify and close these gaps. Even as we adapt, some fundamentals must remain. The first is pragmatism. Laws must ultimately deliver real outcomes for ordinary people. A legal theory that reads beautifully in a textbook or a system that works well in a larger or more homogeneous society may not work well for Singapore. We should learn from others, and we do, but we cannot import solutions wholesale. Our laws and institutions must be shaped by our own realities and circumstances. At the same time, pragmatism alone is not enough. The rule of law is not a machine that you build once and then you leave it to run on its own, automatic. It is a living social compact. It depends on people continuing to believe in it and to uphold it. Once people lose faith in the system, the whole foundation starts to weaken. And that is why public trust matters so much. Our key institutions, the police, the Attorney General chambers, the judiciary, must uphold the highest standards and act with integrity and in the public interest. The moment people think that power is being used for private gain, trust begins to erode. And once trust is lost, it is very hard to rebuild. So in Singapore, honesty, integrity, and respect for the rule of law are non-negotiable. We set high standards, and they apply to everyone. Any breach, however isolated, however senior or junior the person involved, will be dealt with firmly. And that is how we keep our system clean, fair, and worthy of the trust Singaporeans place in it. So far, I have focused on Singapore, but the rule of law does not stop at our borders. What happens beyond Singapore matters too. The same tensions I described earlier play out on the international stage, on a much larger scale and with far higher stakes. Over the past century, nations came together after devastating wars to build a framework of international law. The United Nations Charter, the International Court of Justice, the Geneva Conventions, the Law of the Sea, for example. They did all this because they understood a simple truth. However imperfect, a world governed by rules is far safer than one governed by raw power alone. Unfortunately, today that system is under growing strain. More countries are acting unilaterally and with impunity. International rules are increasingly disregarded with little or no consequence. And when strength replaces right, the system begins to fray. And it's always the smaller and more vulnerable nations that feel the impact first. That is why Singapore speaks up and makes our voice count. We do so in our bilateral engagements and international forums, whether it's ASEAN meetings, G20, or the United Nations. We support international institutions and mechanisms for peaceful dispute resolution. And when fundamental principles are tested, we state our positions clearly and consistently. For example, as a trading nation, Singapore depends on open and secure sea lanes. International law, including the law of the sea, ensures that vital waterways remain open to all and are not subject to arbitrary control. If these principles are weakened, it will not just affect distant regions, it will affect Singapore directly. So this is not just a matter of idealism, it is a matter of national interest. And for a small country like Singapore, a strong and functional system of international rules is vital. It provides a measure of stability and predictability in an uncertain world. On our own, we may not be able to influence how the world evolves, but together with other like-minded partners and many other like-minded partners, we can help to shape the environment around us and strengthen the rules and norms that protect all countries, big and small. And that's what Singapore strives to do. And we will continue to do our part to support and uphold these frameworks and to contribute to a more stable and orderly global system. To conclude, the strong rule of law we enjoy today did not emerge by chance. It was built carefully and painstakingly over generations. In a more turbulent and volatile world, this is one of Singapore's most precious and valuable assets. The rule of law is what keeps our society stable, even when the world around us feels more unsettled. It is why Singapore is trusted when trust is increasingly hard to come by. And it is how a small island of diverse people has been able to forge a strong sense of cohesion and shared identity. Now, for all of you, all of the young people here in this room, and to all young Singaporeans, it is your turn to carry this forward. Your task is not to preserve the system unchanged, but to adapt it, to strengthen it, and to keep it relevant for the challenges ahead. Because the rule of law is never finished. Every generation must renew and protect it in its own way. And if we continue to do this well, Singapore will not just be a place where the rule of law is upheld, but we will be a society defined by fairness, justice, and trust. And that is the Singapore we must continue to build together. Thank you.
I'm Cheng Eng from Pro Bono SG. I am very delighted and privileged to be on this panel with my very esteemed speakers, Minister Edwin Tong, Justice Faisal, and also DAG Goh Yi Han.
Good afternoon to all of you. First, I think rule of law, perhaps most importantly, is the way in which we organize ourselves. It's a framework, call it a rule book if you like, how we do things day to day, and why we expect things to happen in a particular way. If you buy a ticket to a concert, you expect to be let in, right? That is the rule of law. So a contractual framework within which our rights are respected, and it is undergirded by what I think we have in Singapore, which is a first-class legal system, a judiciary that's first-rate, jurisprudence that is well-known all around the world. Our judges, our judgments are well-known around the world, and people have respect and regard for it. And I think that's what reinforces concurrently all the time the strength and the application of the rule of law. And then there's also the criminal laws. It sets out what you expect to see in a society. It underscores the social compact that we have. It tells us what we can't do and what we expect that we can't do, what is wrong, why we can do what we do and why we can't do what we do, and what we regard as wrong or reprehensible even. And when it is done, then yes, something will happen, a consequence will happen. The alternative, I think, is really quite untenable, right? It will be a lawless society, so it's law and order, or as Mr. Lee Kuan Yew famously put it, order first, then law. But whichever way, if you didn't have the rule of law, it will be lawless. The second is, if you look around the world today, I think geopolitical tension, you see people withdrawing from multilateral rules-based systems. So people are not respecting the rule of law, not respecting institutions like UN, WTO, WHO, world institutions. And so Singapore, I think, has to be different. We have to buck that trend. I think we have to be very multilateral in our approach, and we have to do our best to uphold a rules-based system. And the fact that we're able to say that in Singapore we have a strong rules-based system where the rule of law is non-negotiable has also made us an interesting, and if not incentivize Singapore as an investment hub. And in doing so, it gives us jobs, it gives us progression, and it uplifts our society. So that's the rule of law in operation, serving our country economically, growing our country as well. The third aspect of the rule of law is that it gives us a framework for believing and understanding that our social fabric will continually be strengthened. It is the basis on which we believe that no one is above the law. And so no segment of society will rise ahead or fall behind because of who they are. Because the law treats everyone as equal. And that, I think, is the foundation of a meritocratic society, one that believes that we do not judge a person by your background, and that everyone, whatever background you are, must respect the rule of law, and it will apply to you equally. The fourth aspect of it is, for all that we have built up in Singapore as a first-class legal system, first-rate judiciary, it doesn't mean very much if the last person in Singapore, the most vulnerable in Singapore, don't feel that they have access to it. We spent many years, in fact, our attitude towards legal aid and pro bono and assisting those who are not able to assist themselves, it goes back a long way. Just a few months ago, we revised the thresholds so that more people can avail themselves of legal aid, civil legal aid if they need to. We've also assisted with criminal legal aid. We have the class program which Law Society runs. We supported it. MinLaw also put in funding to help to run it. And a couple of years ago, we decided that we will institutionalize public defense. So we set up the Public Defender's Office a few years ago. It's cited within the Ministry of Law. So anyone in Singapore who is charged with an offense who can't afford your own defense, the PDO is available to assist in the right cases. We've also supported PBSG, Pro Bono SG, works with Law Society, and they have lots of great events. And the one initiative that really resonated with me from PBSG was when they really took access to justice and community justice one step further, literally, by setting up a pro bono center in the middle of a HDB estate. If you go and look up Tian De Temple, Tian De Gong, right, in Hougang, you'll see that that's where PBSG is operating a center. Finally, if you think about what is now on the social media, on the internet, We've never had to have laws to deal with social media, chat GPT, AI-generated material content, or even generative AI or agentic AI. So we are dealing with a very different environment. So we will need laws that catch up with it, that keep up with it, that evolves, that is modern, that is fit for purpose today. And I think that's another key feature of the rule of law. It must be not static, it must be dynamic. And we must also recognize that from time to time, we will have people whom we might not have recognized in the past as vulnerable also become people that we need to help. Those with invisible disabilities, how the law affects them, how we treat them. And I realized that that might be a blind spot that we perhaps had missed in the past. So we then set up a task force, and now it is going around working with social service agencies, understanding the dynamics of our population. So the rule of law means all this to me. It means in different ways, different things for different people. But I think most importantly, rule of law means we must come together and have a care. And when we have a care in what we do, I think it will become very commonsensical and very second nature.
I'm going to kickstart the Q&A. So the first question is really about, who gets to write laws and dictates what laws are best for society, because it also needs to reflect some form of societal values and agreement. There was a question on number one, how citizens can be more involved in this process. And number two, it's a related question on how do we decide competing concerns and trade-offs when drafting laws. And how do we decide harms to individuals versus harms to society? So maybe we can start off with DAG Goh. Would you like to start?
Okay, sure. The important distinction between law and policy. At AGC, in drafting laws, our role is not to dictate what the policy is. That is the government's role. And what we do is to make sure that whatever policy that the government advances, it is clearly presented in the law in a consistent way that doesn't contradict existing laws. Now, of course, there is a further legal side to this in that government comes to us with policy. We also advise whether that is legal, whether that is constitutional.
I think DAG is right, and it is true that it is the government that has carriage of policy in laws. And I think it is, the government sits at the middle of society and laws, and it is our job, our duty, to reflect social values, social compact, our social mores that we want to see in our society, in our laws. And I thought I'll give you some examples. We all know that if you harm someone, it's wrong. There are different degrees, and the rule books will tell you that there are different ways of articulating that, right? But if you cause harm to someone in whose trust is in you, trust is reposed in you, and you are in a position of power. I mean, take, for example, a coach and a trainee, or a parent and a child, or an employer and a foreign domestic worker. And if you harm that person treated as a vulnerable person, then we in our society, we want to show a signal that it is reprehensible. We don't accept it, we don't condone it, and because the vulnerable is not in a position to defend him or herself so easily, we want to send a stronger signal. And so in our policy decision, we want to draw a distinction between harming a person and harming a vulnerable person. So we work with AGC and we say we want the rule books to reflect this, to ensure that it is legal, it has a proper framework, it passes muster on the legal principles as well as the rule of law framework, and then we put it into our rule books. So that's how, between executive and government and AGC, we work. I think the question also touches on what young people can do, what role they can play. And again, I thought best to illustrate it with an example. Some months ago, we passed the Online Safety Act. And in a few weeks' time, we will set up the Online Safety Commission. There'll be an Online Safety Commissioner. There'll be a commission that's set up. And if you find that there's something objectionable, there's a harm as listed in the statute, happens online, then you will be able to make a complaint to the commission, and with expedition, some relief can be found. If you asked one of the platforms. You ask Meta to deal with something, it can take you days, if not weeks. You ask Instagram to remove something, you ask TikTok to remove something, it can take you a long time. But with the Commission, you're able to have redress quite quickly. So I believe it is a very progressive set of laws that allows us to protect the vulnerable, the young, those who are subject to abuse, those who are subject to child pornography, for example, from being further damaged online. But did you know that in constructing those laws, we had a group of young people come and talk to us about their experience? We gathered their views, we asked them about their experience online, we asked them what they were most concerned about, we got them to think about what kind of relief would help them in that situation. If you were the victims of these kinds of harms, how would you expect a commission to be able to help you and help your family? And we sat down with them for months to work out what that harm would be psychologically, as well as sometimes physically. And we worked through the procedure, we went back and forth with them, and when we finished, we very proudly said this was something that we worked with them on. And I remember that when I moved the bill in Parliament, they were present in Parliament, and I could see that they felt a sense of pride in being able to contribute. And I think this demonstrates that not all wisdom and not all learning is with one organization. And sometimes it does take many helping hands pulling in the same direction with different perspectives and a diversity of opinions to make something work. And this was one example. I think there's a lot that can be done. If you apply your mind to it, you take an active interest beyond yourself, and those of us who are privileged enough to be in a good position to try and pay it forward, I think we can really make the rule of law come alive, evolve, and really be fit for tomorrow's purpose as well as today's. Thank you.
Thank you, Minister. I'm going to ask Justice Faisal this question that has received quite a lot of votes. What do you think of the view that prosecutorial discretion in capital cases hamstrings judges who want to take personal circumstances into account to avoid imposing capital punishment? For example, in the case of Yong Vui Kong, the sentencing judge had no choice but to impose the death penalty because the AGC declined to exercise its discretion to impose a non-capital trafficking charge.
Thank you for that question. I think that perception is an understandable one, that one wants judges to have discretion. But I come back again to the point that I think both DAG Goh as well as Minister Tong highlighted. Each of us must know what our respective role in the ecosystem is. Each of us must respect the powers that the others have. So in this specific context, and I won't touch on the case specifically, but just thinking about capital punishment as an example. At the end of the day, Parliament will decide, the executive will decide what offences are so heinous and so deserving of capital punishment. To the extent there's a logical basis for that, that is something that must ultimately be given voice to. AGC would undoubtedly, in the legislation process, weigh in on whether this is constitutional. And then at the end of the day, if it is unconstitutional, someone can challenge it and get recourse in the courts. But to the extent it is constitutional, then the role of the courts is not to say, I know better than government about what our social policy should be. I know better than the government as to what the outcome for a specific case ought to be, or that I know better than AGC about what charge is appropriate. And on some level, we have to exercise a certain level of humility to know that we actually don't know a lot about what's going on in terms of why a social policy is the way it is, and perhaps more importantly about what considerations that the AGC took into account. So for example, there might have been background intelligence the AGC takes into account that the courts will not be privy to. So to some extent, the actions of any one actor, whether the government or AGC, appears arbitrary, there's a process to challenge that. So just to take a hypothetical example, imagine a world, and I'm not suggesting this will ever be done, the government enacts laws that say capital punishment for everybody whose surname starts with A, B, and C, but not D, E, and F. Anybody looking at that will immediately go, there's a certain arbitrariness to that exercise. And if one challenges that, one can imagine a court entertaining the arguments. But to the extent it is a value judgment, to the extent it relates to difficult questions of social policy, it is something that the courts will only look from a constitutional lens, and to the extent the decision-making is constitutional, both from the executive and the AGC, the courts will respect that and effectively discharge its duties to sentence accordingly.
Hi, I'm Kritika from Temasek Junior College. Is the future of access to justice ultimately about making people understand the legal system better, or making the legal system understand people better?
Thank you for that question. We have one more question.
Hi, I'm Claire from Dunman High School. So my question today is, in a world where people and countries are starting to act more strongly out of self-interest, how can we navigate these conflicts of priorities while still upholding the rule of law, even if it means sacrificing relationships between people and countries? Thank you.
The question on access to justice, I think you framed it as, is it understanding laws better, or is it the other way around? And I think the answer is really both. For access to justice, which is really an evolving concept, as I mentioned earlier, you've got to have regard to both what the system can do and whether there needs to be changes, and also whether there might be new groups of vulnerable that you perhaps might not yet have taken into account. Or sometimes the kinds of persons you want to include, you might have accidentally or perhaps through passage of time not been able to include. So for example, at our recent COS debate earlier this year, we decided to raise the threshold for qualification into civil legal aid, LAB legal aid. Why? Because we realized that cost values have gone up, incomes have gone up, and also the cost of securing legal assistance has gone up. And we want to make sure that a sufficient number in our society can still avail themselves of legal assistance. And when I say legal aid cost has gone up, it means sometimes when you look at measuring social assistance, if you're giving social assistance on a regular cadence and regular basis, I think you have one way of measuring that. But you know, when you have to appoint a lawyer and you have to come and defend yourself in court, there's a sharp spike at that point in time in the cost. And sometimes families find that there's a tremendous pressure at that point in time. So having reviewed, we decided that it was appropriate to raise the ceiling. So sometimes it's about reacting to circumstances and situations on the ground and revising our frameworks to allow us to be more up to date about who we want to serve. Maybe I'll pass on the other question to one of my colleagues here.
In terms of charging, what had been asked, I would say again, I reiterate that the main task of the prosecution is not to secure a conviction at all costs. So if we have a vulnerable person, an accused person who has vulnerable aspects to him or her, such as mental problems and things like that, the prosecution will take that all into account, evaluate the facts and the evidence before deciding what is the charge that we want to press forward. And in doing so, we do take into account the characteristics of the individual at hand. But maybe I'll make a broader point about the law being understood the other way around that main point, is that I agree entirely with what Minister Tong had said. I think you need both. Laws have to be fit for purpose, but at the same time, if they are fit for purpose and cannot be understood by the man on the street, then it doesn't really help in advancing that purpose. So I don't see it as a binary question, but I see it as a holistic one. Thank you.
It's an important question, and I think I would agree with Minister Tong and DAG Go that it's each side has to meet each other halfway almost. So the system will only function if people understand it. There's no point having the best possible system in the world, but nobody can make any sense of it. So you do need some level of legal literacy, letting people understand what some of the nuances are in order for the system to function effectively. But at the same time, one must also make sure we don't go to the other extreme, where you insist people have legal literacy, but never really reflect on whether your systems can be improved in a way that would allow people, number one, to understand it better, and number two, to be more fit for purpose. So for example, in legislation, there was, over the last few years, a very big exercise about looking at every piece of legislation and thinking, even if the intent is sensible, is there a simpler way to crystallize that intent and changing the wording such that somebody reading it wouldn't, as DAG Go suggests, go to sleep immediately? Instead, they will read it and they will broadly understand what the purpose of the exercise is. So that's an ongoing conversation. So I think the system certainly should meet people halfway, but part of the solution in my mind is also legal literacy. But back to your question, Cheng Ying, about how we take into account vulnerable victims. So DAG Go, I think, had given a very good exposition about the AGC's perspective. But when the matter comes to court, ultimately, we are informed by two considerations. Firstly, the circumstances of the offense, and that is relatively objective. But secondly, and just as importantly, the circumstances of the offender. And to the extent a person was laboring under mental ailments, for example, that is always something that's taken into account in the sentencing equation. So we do appreciate the fact that there are a wide variety of offenders that come before the court, and the sentences are calibrated accordingly in that respect.
Thank you, Justice Faisal. Claire had a question about the rule of law. Minister Tong, would you like to take this question?
Thanks. I think it was by Claire, right? Somewhere over there? Yes, hi, Claire. I think it's important to understand that in Singapore, our concept has always been very clear. We do everything we can to advance a person, an individual, someone in society, but never at the expense of the broader community. That's always been the cornerstone principle in the way we organize our laws. It's different in some other countries. In other countries, you might look at the right to freedom very robustly, sometimes, in my view, too robustly. The freedom to carry guns as you like. It comes at the expense of the broader community, and we've seen some examples in the US. Every time there is a shooting in the US, in a school, in a high school, we are sad about it, we criticize what's happened, but it happens again a few months later in a different state. I don't subscribe to that. I think that our laws must have a consideration for what's in the public interest, what is in society's interest as a whole. So we do what we can, we promote individuals as much as we can, but never at the expense of the overall well-being of society in Singapore.
Yeah, I'm Nizan. I'm a year 1 accountancy student at SUSS. So my question was more towards how would legal frameworks take into account of dilemmas which are coming up as time progresses? For example, with artificial intelligence coming up, and if, for example, there is a harm caused by an artificial intelligence tool, and who will be taking accountability for that? How would the restitution processes be for those who are harmed? And for those who are unwilling to step forward because the restitution process might be impossible to prove who has caused the harm, who is responsible for it, how might they be encouraged by the legal framework?
Thank you for the question. I would say that the law responds to advances in legal technology in two or three ways. Number one is, of course, by new legislation that's passed by Parliament to address the very harm in question. But as you will understand, this takes time because government needs time to assess the situation, pass new legislation, and then for that legislation to be applied in practice. The second, I think, more flexible way is through the interpretation of existing legislation. Now, legislation might be drafted in very broad language, and the broadness of the language allows, within limited situations, for the courts to interpret the words to apply to new situations. So that's another way for a more rapid response to new situations that might come about. The third way is, of course, through the common law. Now, the common law refers to law that's made by judges. So judges decide cases that constitutes a body of common law. Some of these claims that you talk about, restitution and the like, may not be grounded in legislation. They might be grounded in the common law, and in that regard, judges can, within limits, develop the common law to respond to a new situation. So I give you an example. Many law students will know this. A long time ago, there was this case called Donahue and Stevenson, where the UK courts created, effectively, a new cause of action in the tort of negligence to deal with a new situation. So that, I would say, are the three ways where legal frameworks can evolve to deal with new emerging legal technology. Thank you.
So I suppose in terms of how it's interpreted, again, the court ultimately is in a position where it will be assisted by both sides whether it is AGC or a private counsel or even a self-represented person, to hear the different perspectives. And I think it's important for the court to ultimately be open-minded about what the arguments are for what punishment should follow or what civil recourse should follow. And then ultimately it calibrates the outcome in accordance with the arguments, the law, and the facts. So coming back to what DAG Goh highlighted about new law. So there was this case called ACB and Thompson Medical. So in that case, the court created effectively new law. It recognized an entirely new course of action in relation to those factual circumstances. And in terms of how that process then works out, once the court articulates that as the law, under the common law, that is effectively the law. And let's say, for example, if the court says, okay, so A pays B X number of dollars, as the case may be, then there's an enforcement process for that to take place. Normally, that is quite automatic because the two parties will just discuss and they will facilitate those payments. But if not, there is an actual process of coming to court and being able to enforce that judgment against the other individual. The same logic as well applies in the criminal context.
And with that, I'm going to wrap up today's dialogue. Thank you very much.